Jury not present.
The court said, "Please have the witness resume the stand and please bring the jurors in."
Jury present.
The court said, "Please be seated. Remember that you're still under oath."
The witness said, "Yes, ma'am."
The court said, "You may continue your cross-examination."
Mr. Kamraju said, "Thank you, Your Honor."
By Mr. Kamraju.
So I think when we left off, you were reviewing a document on your screen. I'm just going to direct you, to help to orient you. I'm happy to show you the first page again, but otherwise, I'm going to direct you to the last sentence of this paragraph.
My memory is this is a document produced out of the arbitration.
Okay. And does this document help refresh your recollection as to whether Mr. J.'s offices in London occupied several floors of an office building?
Yes. I'm not sure I went to any other floors than the one I was on.
Okay. That wasn't my question, just simply that there were multiple floors of the business, right?
According to this statement, yes.
And it was your impression that the businesses employed a lot of people, right?
Millimeter whom?
More than 100.
My memory is it was approximately 200.
Mr. Kamraju said, "We could take that down for now." Thank you. Now I think before we looked at that, you were explaining some of the reasons why you chose to go with Hamilton and the Himalaya Exchange companies for the acquisition. Right?
The court said, "Mr. Kamraju, speak into the microphone."
Mr. Kamraju said, "Sorry, Your Honor." And one of those reasons was that you perceived a synergy between the bank and the exchange, right?
Yes.
And you were telling your shareholders that, right?
Yes.
Okay. Can you explain what you thought the synergy would be between the bank and the exchange?
Well, we had always planned on having a crypto exchange, a digital asset exchange, as part of our offering, and had not launched it yet. So there was the potential for us to work closely with a digital asset exchange that happened to own a large portion of us.
And given your prior interest in starting an exchange, you had some ideas as to how to improve the Himalaya exchange, right?
Yeah. We didn't get very far along that path.
Sure. But you made some initial suggestions, right?
I don't remember what they were.
Okay. Well, let me ask you this. You previously invested in Bitcoin, right?
Yes.
Okay. One of the ideas that you suggested to the exchange was that they should list Bitcoin too, right?
Mr. Finkel said, "Objection. 401, 403.
The court said, "You may answer."
I don't remember that specific suggestion, but it seems reasonable.
Okay. You were aware at the time that the Himalaya exchange started that it only listed 2 tokens, right?
Yes.
Okay. And that was H-coin and H-dollar, right?
Yes.
And so it made sense to you that it should list more tokens.
That's reasonable.
Now you discussed some of those suggestions with David Fallon, right?
That's who I would have discussed it with, probably.
Who is Mr. Fallon?
I would best describe Dave as the head trader of the firm.
Okay. And just so we're clear, when you say, the firm, which firm are you referring to?
Well, he was like many of their employees, who worked for many of the firms.
Okay. Did he work for Hamilton as one of those?
Yes.
Okay. Did he work for the exchange as one of those?
The Himalaya Exchange?
Yes, sir.
Yes.
Okay. So he played a role at several of Mr. J.'s companies, correct?
Yes.
And I believe you testified to this, but Hamilton was a hedge fund owned by Mr. J.E., correct?
Owned is a difficult word, but controlled by Mr. J would be better.
Okay. Fair enough. He controlled it, right?
Yeah.
All right. And prior to reaching your deal with the exchange, you did due diligence on the exchange. Right?
Yes.
And the exchange did due diligence on the bank, right?
I believe so.
And as part of that mutual due diligence process, you traveled to London, right?
Yes.
You spent a few weeks there at Mr. J.'s offices, correct?
Yes.
On the bank side, were you the only person involved in that due diligence?
No.
Okay. Who else was involved?
My compliance team, my legal team, my CFO.
Okay. And on the exchanges side, who did you interact with when it came to that due diligence?
Priya Patel, Georgette, David, there was a young gentleman that was sort of an analyst. Whose name I can't recall. Oh, Harrison was his name.
Okay. So as part of that due diligence process, you didn't speak to Mr. Gov't, right?
No.
Okay. You didn't speak to Yvette Wong, right?
No.
Now as part of that due diligence process, there was an independent valuation done, right?
Yes.
And that was of what the bank would be worth with the investment, correct?
Correct.
Okay. I'm not going to ask you to get into particulars. But you provided the information for that valuation, right? About the bank, I mean.
We provided the information that related to the bank for that valuation.
Yes. Sorry. My question was unclear. Specifically, just so the record is clear. The information that went into the independent valuation about the bank came from you, not Mr. J.'s companies, correct?
I believe so.
Okay. And you believe that this transaction could generate significant value for the bank, right?
I did.
Okay. Both in the short term because of your cash flow crunch, right?
Correct.
But then also on longer term, right?
I'd like to go back to timelines. Because you're conflating a bunch of information as though it all happened at once. The first investment that Mr. J made occurred long before we were working on any analysis of the valuation. The valuation, as I recall, occurred, or began, around February or March. And I don't remember exactly when we received a report, and the larger investment dollar amounts. Those discussions didn't happen until after he had made his first investment. So that's the answer to your question.
Okay. So just so we're clear, you had long-term plans for the bank, right?
Define long-term.
Okay. You had plans to help try to grow the bank, right?
Yes.
And they weren't going to happen the day after you signed the deal, right?
No.
Okay. How long did you think it was going to take to grow the bank to the scale that you envisioned?
Several years.
Okay. That's what I mean by long-term then, okay?
Okay.
So over the course of withdrawn. So some of the money that Mr. J.E. was going to invest was intended to fuel long-term growth, right?
Yes.
And you believed that that could greatly increase the value of the bank, correct?
Yes.
In fact, you told Mr. J.E. at one point that you thought the bank could be worth $1 billion, right?
Mr. Finkel said, objection.
The court said, overruled. You may answer.
I don't recall having that specific conversation. But there is a scenario where it could be worth that.
Okay. Now I think in the answer you gave a second ago, you alluded to this. But the total money that was going to be sent from Mr. J.E.'s companies to your companies was broken up into chunks. Right?
3 parts.
Okay. So can you explain to us just what the 3 parts are?
There was the initial investment, which required very little approval and no approval by the regulator. I believe that amount was roughly $2.7 to $3 million. There was what we would call the September 16th close, which was $49.5 million additional. And it was contemplated that in or about 6 months later, we would fund another $50 million into the bank.
The court said, what do you mean by we would fund?
The witness said, I'm sorry. Well, post-September 16th, our executives of the bank would be working for William J.E. and the Hamilton Enterprises, so that's what I meant by we collectively, but it would have been Hamilton's money.
The court said, go ahead.
By Mr. Kamaraju.
And the latter of the two chunks that you talked about, so not the initial investment that didn't require OCIF approval but the two chunks after that, are we clear?
Yeah.
Those were each to be made pursuant to separate agreements, right?
Yes.
But both sets of agreements were signed on September 16, 2022, right?
Which agreements specifically were signed?
Sorry. I mean the agreement related to the second chunk and the third chunk, right?
I don't recall if we documented the third chunk on the September 16th closing.
Okay. So what agreements were signed? What agreements were signed as part of the September 16th closing?
A number of agreements. Quite a few, actually.
Do you remember any?
I couldn't enumerate them for you.
Okay. Those agreements were agreements that upon, withdrawn. Pursuant to the agreements signed on September 16, 2022. You were expecting that Hamilton was going to wire you money, right?
Yes.
So at least there was one agreement signed on September 16, 2022, that obligated, in your mind, Hamilton to send you money. Right?
Yes.
Okay. And how much money did you believe Hamilton was supposed to send you?
$49.5 million.
Okay. So there was one agreement signed on September 16 of 2022 that you believed obligated Hamilton to send you approximately $49 million. Correct?
Yes.
The court said, and when was the money due?
The witness said, it was actually due on the 16th.
Okay. And you testified on direct that you actually didn't get the money on the 16th, right?
Correct.
And you weren't expecting it because it was late in the day on a Friday, right?
It's reasonable to assume that the wire process might have been slower than hoped. But it could have cleared. It wasn't that late in the day.
Got it. But it didn't shock you.
It did not shock us.
But you had received notification that Hamilton had actually tried to send the wire, right?
The interpreter said, "Counsel, please slow down."
Sorry. You had received notification that Hamilton had tried to send the wire by that time, right?
We received a copy of the wire instructions and receipt that was sent to Hamilton.
All right. So you testified on direct that the reason why the money never made it to Mercantile was because I think you said the U.S. Marshal seized it. Right?
Yes, sir.
Now after the money didn't show up on the 16th, you continued to communicate with Hamilton about the wire. Right?
Yes.
Because you still thought there was a chance for the deal to go through, right?
We didn't know what was happening until almost Thursday of the following week. So about the 22nd or 23rd.
Okay. And you were following up with Hamilton because you wanted to see if there was a way for the deal to keep going. Right?
We wanted to receive the $49.5 million.
Yeah. Pursuant to the investments that Hamilton was going to make, right?
Correct.
And you testified that wire was supposed to come from the Silvergate bank account, right?
Yes.
And you thought that, well, let me ask you this. Withdrawn. There was a OCIF approval in place for the transaction, correct?
Correct.
And did the OCIF approval set a deadline for when the transaction would have to happen?
Yes.
When was that deadline?
September 16th.
Okay. So did you believe that the deal was dead pursuant to the OCIF approval?
No.
Okay. Just to be clear, so I can ask the question.
Sorry.
That's okay. When the money didn't arrive on the 16th, in your view, did that kill the deal under the OCIF approval?
No.
Okay. So the deal could have still gone through even though the OCIF deadline had been missed, right?
Our initial view was if it were nothing more than clerical error. That OCIF would have viewed money received on Monday or Tuesday as sufficient. But that wasn't ultimately the cause of the delay.
Right. But in essence, if you missed the deadline by a few days due to an explainable error, you thought OCAF would let it slip, right?
I wouldn't use that terminology, but
let it go through.
They would understand.
Fair enough. But there was some urgency there then to get that situation resolved, right?
Yeah.
That's why you reached out to the CEO of Silvergate, right?
Correct.
You wanted to push this along, right?
Yes.
Because the faster it got resolved, the better, right?
Yes.
Because at some point, you never know, OCAF's patience may run out, right?
I think that's a fair assessment.
Now Hamilton advised you that the marshals had seized the funds, right?
Yes.
Silvergate Bank wouldn't give you that information, right?
Correct.
And you then had another discussion with Mr. J.E. about potential options to fund the transaction, right?
I don't recall that.
You don't recall speaking to him on the phone about other options?
No.
Okay. So the Silvergate reach-out was the last option you thought they had, is that right?
Once we learned that the funds had been seized by the US government, we did not believe we wanted to be in a position with our regulator to close the transaction because there has to be good reason for funds to be seized.
I'm sorry, sir. I don't understand the connection between we wanted to complete the transaction and there had to be a good reason for funds being seized. Can you explain that to us?
Until we learned what had happened to the money. Which was about, I believe, Thursday the 22nd, we did not know what had happened to the money. If it was simply a clerical issue, then I believe OCIF would have accepted the transaction and we would be moving on. But that's not what happened. It was seized by the US government, and there's requirements. I'm not a lawyer. I can't describe what those requirements are. But there are requirements of having some legitimacy to seizing the money. And I believe it has to be approved by a court. So from the perspective of BSA and our relationship with the regulator, it did not make sense to expect that the transaction would eventually close with him or anybody else involved in his side of the organizations, him being William J.E.
Did you tell Mr. J.E. that?
I'm not sure if I did.
Now you have personally spoken with the commissioner of OCIF before, right?
Yes.
Did you call the commissioner up and say, hey, this money has been seized? We're calling the transaction off.
That would be very unlike me to do that, so I don't believe I did.
Okay. Did you direct your counsel to write a letter to OCIF saying, hey, the money's been seized? Let's call the deal off.
That is most likely how we communicated, or our counsel called on our behalf.
Okay. But you don't know one way or the other, right?
I don't recall.
Now you testified during the arbitration proceeding, correct?
Yes.
And that testimony was under oath, right?
Yes.
Just like you're under oath today, right?
Yes.
And you remember being asked during your testimony, now. Do you recall a WhatsApp conversation with William where he was trying to redeem his own cash, his own HDO into cash? To try to complete this transaction, and responding, I recall a conversation about that, yes?
Mr. Finkel said, object. This mischaracterizes what defense counsel is trying to impeach on. That's not what the witness testified about at all.
The court said, sustained.
Okay. Did you have a WhatsApp conversation with William to try to discuss him redeeming his HDO to fund the transaction?
We had many WhatsApp conversations during that period. It would not have been unreasonable for me to have one about that. I don't recall the specific details.
Okay. You don't recall.
The details.
Mr. Kumraju said, okay. Then I'd like to pull up just for the witness. I only want you to read it to yourself, okay? And just for the record, I'm showing just the witness and the parties and the court what's been marked with the Bates number Mercantile DOJ 0078835. Okay. Sir, could you just read lines 13 to 17, to yourself, please?
Can you take the blow-up down? I'm sorry. Yeah. Thank you. Okay.
Does this refresh your recollection about whether you had a WhatsApp conversation with Mr. J.E. about his trying to redeem his HDO into cash to fund the transaction?
It does.
Mr. Kamaraju said, okay. Now could we take that down and could we show just the witness and the parties what's been marked for identification as DX60556? Please. Take a look at that on your screen, sir. Do you have it there?
Yeah, I do.
Okay. These are WhatsApp messages that you received from Mr. J.E., correct?
Yes.
And you received them on September 23, 2022, at 2:01 a.m., correct?
Yeah, the timestamps are unclear if they're US times or Ireland times. Which is where I was at the time.
Okay. But at least what's reflected on the document is 2:01 a.m.
Yeah, that's what it says.
Correct. And the subject matter of Mr. J.E.'s messages involve redeeming money, right?
Yes.
Mr. Kamaraju said, okay. The defense will offer DX60556, Your Honor.
The court said, any objection?
Mr. Finkel said, no objection.
The court said, it is admitted.
Defendant's Exhibit 60556 received in evidence.
Mr. Kamaraju said, okay. Could we publish that, please? And could we actually bring up alongside it GXMR 1205? Which is in evidence.
By Mr. Kamaraju.
Okay. Do you have both documents on your screen?
Yes. The one ending in 1205 is just a header.
I'll flip through it in a second, but... Mr. Kamaraju said, okay. So let's turn the page on 1205 to the first page, please. Okay. Do you see, at the very top of both documents, where it says, messages in chronological order?
Yes.
Okay. And on the left document, do you see what's in the parentheses there?
Times are shown in GMT plus 00.
Okay. And then on the right document, do you see the same message?
Yes.
Okay. So you would agree with me, sir, that both these messages reflect the same time zone, correct?
I just agree that's what the document says.
Okay. Fair enough. These two exhibits both reflect that, right?
That's what the document says.
Okay. And so the document on the left, DX60556, says that those messages were sent before the messages on the document on the right, right?
Yes. Yes.
Okay. Now you testified on direct that Mr. J.E. did not tell you who this redemption was going to be for initially, correct?
Yes.
Now on the left, in the message from 2:01 a.m., could you please read that to the jury?
They're both from 2:01 a.m.
Let's start with the one at the top.
Okay. Hi, as discussed. My company would like to redeem some money so that we could continue to support the operation of your bank and other entities.
And then what does he go on to say?
We'll send you the instruction in the morning.
Okay. And then in Government Exhibit 1205, he sends you the instruction, right?
I can't see. Oh.
Mr. Kamaraju said, you can just put 1205 up on the screen. You can take the other one down.
We talk about my meeting with Masud, we talk about FV Bank. He mentions he's doing a normal redemption of a client. Scroll down some more, please. I mention I'm on a call with my attorney. He mentioned documents for ACA. Do I need to go further?
Government Exhibit MR 1205 reflects the only redemption request that Mr. J.E. sent you on September 23, 2022, correct?
Correct.
Okay. And in the exhibit we were looking at, DX60556, which had the WhatsApp chats from earlier this morning, He said he was going to send you instructions for a redemption. Correct?
Yes.
So the instructions were for this redemption that's referred to in Government Exhibit 1205, correct?
I don't believe the two things are connected.
Okay. So did he send you instructions for any other redemption later that morning?
To be clear, William and I never talked about him using funds to invest in our bank after this moment. He sent a message at 2:01 in the morning that I didn't respond to, and then later, he sent in separately a redemption request via ACA Capital.
Okay. So my question was, did he send you any other redemption requests on the morning of September 23, 2022?
Mr. Finkel said, asked and answered.
The court said, sustained.
Mr. Kumraju said, then I'm going to move to strike his last answer as non-responsive.
The court said, answer is stricken.
So let me try that question again. Did you?
The court said, so I sustained the asked and answered objection.
Mr. Kumraju said, I'm sorry, Your Honor. I thought once it was stricken, I had the chance to go back. Fine. How many redemption requests did Mr. J.E. send you on the morning of September 23, 2022?
I believe one.
If we can scroll down to page 3 of this exhibit. Do you see there's a message from Mr. J.E. at 8:29 p.m.? Sorry. Go back. It's the second message from him at 8:29 p.m. Do you see that?
We'll call you on how to complete your banking deal as well.
Right. You only had one banking deal going on with Mr. J.E. at that time, right?
Yes.
And that was the acquisition of Mercantile, right?
Correct.
Now you didn't say to Mr. J.E., during this government exhibit NR 1205, hey, William. We can't do a redemption request because the money's been frozen, right?
I don't recall making that statement.
You didn't make any similar statement either, right?
I don't recall.
You at no point communicated to him that you had a concern about the seizure impacting this redemption request. Correct?
Once I learned of the seizure, I was in listening mode.
Okay. So you didn't convey it to him, right?
I don't recall making a statement like that.
Now you said you were in listening mode. You were in listening mode because you anticipated commencing an arbitration, correct?
We were just simply trying to sort out what was happening.
Okay. But you did commence an arbitration, correct?
We did.
And you commenced that arbitration after learning that the Department of Justice had seized the money. Right?
Yes.
And in fact, you commenced that arbitration pretty quickly after learning that fact, right?
Yes.
Within days. Right?
I don't know the specific number, but it was quickly.
And how about September 30th, 2022, is that when you started the arbitration?
That sounds about right.
Now the DOJ had seized the money, right?
The wire.
Had seized the wire. You were suing for those funds, right?
Correct.
That's what you were claiming as damages, right?
Correct.
How was Hamilton going to pay you that money if the DOJ had seized it?
Mr. Finkel said, objection.
The court said, sustained.
Okay. What was your understanding of how Hamilton was going to do it?
Mr. Finkel said, objection.
The court said, sustained.
Okay. Why did you file an arbitration seeking the wire money knowing that DOJ had seized it?
Mr. Finkel said, objection.
The court said, sustained. He did not testify that he was seeking the wire money.
Mr. Kumraju said, he did, Your Honor.
The court said no.
Okay. Let me try it this way. Why did you file an arbitration asserting damages based on Hamilton's failure to send the wire to you?
Why did we do that? Because I have a responsibility to my shareholders to protect the asset of the bank.
Did you believe that Hamilton had other money that it could use to pay you?
Mr. Finkel said, objection.
The court said, "You may answer."
I don't think that's important to the analysis, given the fact that we had an obligation to protect our legal interest.
So you spent money on the arbitration, correct?
I think that's confidential and privileged.
You paid lawyers, right, sir?
Yes, so that's privileged, I believe.
Well, the judge is right there. I'm not asking you for any communications that you've had. I'm simply saying you paid lawyers.
The court said, "So what you and your lawyer talked about, that's what's privileged. But the fact of making a payment is not privileged."
The witness said, "I did not make a payment."
I'm sorry. I just want to make sure. You did not pay.
We did not. We took a contingency arrangement. There might be some minor out-of-pocket fees that we paid for.
Okay. Now, prior to filing the arbitration, you had visibility into the bank accounts that Hamilton had at Mercantile, right?
Yes.
Okay. There was money in those accounts, right?
Yes.
Millions of dollars, right?
Yes.
And there were Himalaya exchange accounts there too, right?
Yes.
And there were millions of dollars in those?
Yes.
Okay. Did you ever ask Mr. J.E. to use any of that money that was at Mercantile Bank to fund the transaction?
It became clear to us at that point in time, once we learned of the government seizure, that the regulator would not support a closing transaction. Nor do I think we could suggest that it would pass BSA standards.
What about before you learned about the seizure?
What's the question about before you learned?
Before you learned about the seizure, did you go to Mr. J.E. and say, "Why don't you just use the money that's already at the bank?"
No.
Now, as of September 16, 2022, it's fair to say that Mercantile had more than $300 million on deposit, right?
We had a lot. I don't remember the exact number.
Okay. Hundreds of millions.
Yes.
Okay. And most of that money came from either the Himalaya Exchange or Hamilton, right?
I believe so.
North of 80%, right?
It was substantial.
Okay. Also hundreds of millions of dollars, right?
Yes.
And of those hundreds of millions of dollars, a significant portion was meant for Himalaya Exchange customer redemptions, right?
Mr. Finkel said, "Objection, Foundation."
The court said, "You may answer."
They communicated with our compliance department about the nature of the funds. I don't believe they communicated to us about what their future purpose would be.
Okay. When we looked at the redemption request from Mr. J.E.
Yes.
That was to redeem money from Mercantile.
No.
Well, Mercantile was being asked to send a wire, correct?
Yes, but the redemption was between ACA Capital and Hamilton Exchange, SIC.
Understood. But the end product of that redemption, from Mercantile's perspective, was to wire out money, right?
We received instructions to wire money that was related to the redemption between ACA Capital and the Hamilton Exchange, the Himalaya Exchange.
Okay. And you didn't honor that redemption request, right?
We did not.
But if you had honored it?
Well, I object to calling it a redemption. From our perspective, it's not a redemption request, it's simply a wire request. I did not honor the wire request.
Okay. So let's use that term.
Okay.
Wire request. So let's just make sure we're clear. There was a redemption event that happened. In your mind, within the exchange, right?
Millimeter whom? Yes.
Okay. And then, as a product of that request, then your bank would have wired money out of a specific account at the bank, right?
Correct.
And there was an account designated at the bank for that purpose, right?
Correct.
And that bank was not withdrawn. That account was not limited to only redemption requests related to Mr. J.E. or his companies, right?
I don't know what you mean by limited. The account was in the name of the Himalaya Exchange. The funds redeemed owned by the Himalaya Exchange. They had exclusive authority over the funds. So I don't know what you mean by designation or, it's pretty simple.
I just mean if another Himalaya Exchange customer other than Mr. J.E. had wanted to do a redemption and then receive a wire, they would have come from that same account.
Mr. Finkel said, calls for speculation.
The court said, sustained.
Okay. Prior to Mr. J.E. making that request, had Mercantile Bank wired out any money based on a Himalaya Exchange redemption request?
I don't recall.
Okay. Was that the first one you had ever come in contact with?
Me personally? Yes.
Okay. Now you testified that FV Bank is another bank in Puerto Rico, right?
Yes.
And you learned that the Department of Justice had also seized exchange money that was held at FV Bank. Correct?
That was our understanding, based on rumor.
I'm sorry. That was based on rumor?
Yes.
Okay. Well, Mr. J.E. also told you that, right?
Later, yes.
Well, as of September 23, 2022, you guys both knew about that fact, right?
I don't recall the exact day he told us, but they did communicate that.
Mr. Kumraju said, okay. Could we pull up GXMR 1205, please?
The interpreter said, Your Honor, can you please ask both parties to slow down? Thank you.
The court said, all right. Please slow down.
Mr. Kumraju said, I will slow down, Your Honor. I apologize.
By Mr. Kumraju.
Okay. Could you read the third message down?
He only knows FV Bank is frozen. He did not know the fund nor the transaction issues.
Okay. So that's Mr. J.E. talking to you, right?
Yes, on September 23rd.
Okay. And you understood what he meant when he said, he only knows FV Bank is frozen, right?
Yes.
That's the seizure, the DOJ seizure at FV Bank, right?
Well, it says frozen, so it might have been a freeze. It was unclear.
The court said, who is he referring to?
The witness said, Masid, who's the CFO. If you look up earlier, I'm saying I'm speaking to Masid at 11, and I asked if he was aware of what's happening, and he said, he only knows FV Bank is frozen.
Now at the time of this message, the Department of Justice had not seized any money yet at Mercantile Bank, right?
No.
That wouldn't happen until much later, right?
Correct.
But based on the FV Bank seizure, you had concerns that the DOJ would come and seize money at Mercantile. Right?
I'm sorry. Can you ask the question again?
Sure. Mr. Kumraju said, I'm sorry, but would you mind reading it back, please?
The court said, go ahead.
Record read.
We just didn't know. If you say I have concerns, we had concerns about many things.
That was one of them.
Yes.
And so you approached the exchange about taking a compliance fee, right?
We didn't approach them. We notified them.
Okay. You told them.
Yes.
We're going to take a compliance fee.
Legal and compliance.
Okay. And the legal and compliance fee was going to be 10% of what was in the Himalaya and Hamilton accounts at your bank. Right?
That sounds about right.
Okay. And the exchange objected, right?
Yes.
You took the money anyway, right?
Yes.
And it was about roughly $28 million, correct?
That sounds about right.
And you pulled that money out of the customer bank accounts, right?
No.
You put it into its own restricted account, right?
I didn't pull the money out of the customer bank accounts.
Okay. So the $28 million that we've been talking about, it stayed in the same Hamilton accounts?
Oh, I'm sorry. I misunderstood what you were saying.
Okay. Sorry. It might have been a confusing question. Go ahead.
We took the money out of the Himalaya and Hamilton-related accounts and put it aside.
Okay. Into its own account, right?
I don't recall the specific structure, but that sounds right.
But an account that wasn't in Hamilton or Himalaya Exchange's name, right?
Correct. Correct.
And as a result, withdrawn. And you did that because you were worried that the Department of Justice was going to seize the Hamilton and Exchange accounts at Mercantile and thus you wouldn't be able to take that $28 million. Correct?
I have legal opinions from my internal and external counsel that.
No. I just want to.
Let me answer the question.
No. I just want to make sure you didn't disclose any of the actual.
That's why I'm flagging it. Much of that was handled by them. So it's hard for me to agree with the characterization of your words, but that is not unreasonable.
Okay. And like I said, not asking for your communications with counsel, just for what's in your head. That made sense to you, right?
That's a reasonable approach.
And that's the approach you took.
I believe that's the approach we took.
Now the Department of Justice came and asked for that money back, right?
Yes.
And you gave them some of that money back, right?
Yes.
But not all of it, right, sir?
No.
Mercantile kept around $5 million, right?
I don't remember the precise number, but that's approximately right.
Okay. And I'm not holding you to a precise dollar figure, but it's in that area, right?
Yup.
And Mercantile spent that money, right?
We posted it with attorneys too.
I'm sorry. I didn't understand.
We posted it with attorneys. That we felt like we needed representation because of all the noise that's going around.
Okay. So you used it to hire lawyers, right?
Yes.
And you were using it to pay the bank's legal fees, right?
Yes.
And that was money that had come from Himalaya Exchange customers, right?
No.
So it was not your understanding that the ultimate source of that money was Himalaya Exchange customers. Sir, that's your testimony.
Mr. Finkel said, asked and answered.
The court said, sustained.
Now you originally took your legal and compliance fee because you thought you had certain obligations to the government. Right?
And we needed to defend ourselves because we didn't know what was happening.
Right. And both your defense obligations and your obligations to the government required you to respond to requests for information. Right?
Yes.
And you wanted to be able to pay lawyers to do that, right?
Yes.
But you didn't want to spend your own money on that, right?
I'm not following you.
Well, you didn't want to spend money that the bank already had, right?
We didn't believe we contractual needed to. We could spend the deduction that we took out of the account because that's what the contract says.
Okay. And that contract that you're referring to says that you can take money out for compliance and legal costs, right?
Yes.
But that's not all you used the money for, is it, sir?
I'm not sure.
Well, didn't you use some of the money to buy an F1 sponsorship?
No.
You don't recall testifying to that during arbitration?
I don't believe we used the money for legal and compliance to buy an F1 sponsorship. We did buy an F1 Academy sponsorship, which was much cheaper than an F1 sponsorship. That was the first women's league for F1 drivers.
Okay. Did the bank have its own money that it could spend on that Academy sponsorship?
Yes.
So the bank had the money to spend on the Academy sponsorship, but not on its own legal bills, right?
Mr. Finkel said, objection.
The court said, overruled. You may answer.
We were just operating according to our contractual rights.
Did your contractual rights allow you to exercise control over fraud proceeds?
That's a question that really an attorney needs to answer.
I'm just asking your understanding, sir.
I don't have an understanding of it.
So that never occurred to you?
I think we had it reviewed by counsel and they responded.
Okay. So even though you moved money out of those accounts and then spent it on corporate expenses, the Department of Justice has never suggested that they were going to charge you or anybody at Mercantile with a crime. Right?
They have never said that they would not charge me with a crime.
I asked the other question, sir.
What was the other question?
Have they ever said that they're going to?
No.
These folks here have never said that to you, right?
No.
And you're here, you don't have any kind of agreement with them with respect to that, right?
Be more specific. I don't know what you mean.
Have you ever heard of a non-prosecution agreement?
Not really. This is my first criminal trial.
Okay. So it's fair to say you don't have one with them, right?
I do not have a non-prosecution agreement.
Mr. Kumraju said, no further questions at this time, Your Honor.
The court said redirect?
Redirect examination. By Mr. Finkel.
Mr. Collins. Do you know what representations Miles Gw't made to customers of the Himalaya Exchange concerning whether, do you know what representations Miles Gw't made to the customers of the Himalaya Exchange?
Other than some of the marketing material I've seen, which I'm not sure I'd style as representations, I don't really have knowledge.
Do you speak Mandarin?
No.
Do you know what the H-coin lockup is?
No.
Do you know what AII is?
No.
What about A10? Do you know what that is?
A 10. I feel like that came across in something I looked at. But I really don't know what it is.
Mr. Finkel said, if we can pull up MER8, please. You were asked some questions during cross-examination about the redemption or wire transfer that William J. sought to get out of Mercantile Bank. Is that correct, sir?
Yes.
Now can you tell us, please, where William J. wanted to send that redemption, that wire?
To a bank called First Abu Dhabi Bank based in the UAE.
Did he suggest sending it to Silvergate Bank?
No.
Did he suggest sending it to Mercantile Bank?
No.
You were asked on cross about whether you thought there was a difference between the messages that you received at 2 a.m. and the sort of rest of the messages with respect to a different transaction. Do you believe there's a difference between the two?
Very much so.
Can you explain why?
As I mentioned, I didn't respond to the prior messages. We never had a conversation about how they could continue the transaction with the bank because it was clear to us that the regulator wouldn't approve the transaction. Nor did I feel comfortable proceeding with a partner that appeared to be the target of serious criminal prosecutions.
You were asked some questions about Mercantile's due diligence. Is that correct, on cross-examination?
Yes.
And I believe you said that part of the due diligence process is relying on attestations by the client?
Yes.
What do you mean by that?
We ask all clients to make certain attestations for some of it's simple. Like who are the UBOs of the business, and we rely on their statements in part to understand the reality.
So the passing of due diligence by Himalaya Exchange relied on statements made by employees of the Himalaya Exchange. Is that fair to say?
Very much so.
And the passing of due diligence by G Clubs relied on statements made by employees of G Clubs. Is that fair to say?
Very much so.
And same for G Fashion. Is that true as well?
Yes.
And you were asked some questions about what evidence you may have seen regarding the Himalaya Exchange and the UBO event. Do you remember those questions?
Vaguely.
Have you attended this trial?
No.
Do you know who the other witnesses are at this trial?
No.
Do you know what the testimony has been or the exhibits that have been introduced?
No.
Is part of the due diligence process at Mercantile Bank obtaining recordings of meetings between Miles Gov't, Yvette Wong, and William J. about use of funds?
Mr. Cumraju said, object to the form.
No. No.
The court said, overruled. You may answer.
Have you heard recordings of William J. Miles Gov't and Yvette Wong discussing use of G Club's funds?
No.
Mr. Cumraju said, same objection.
The court said, overruled.
Fair to say those recordings are not part of your due diligence process at Mercantile?
I'm not sure we knew they existed.
Do you know who Haitham Khaled is?
No.
The term, like-minded individuals, was that your term or Ana Izquierdo's term?
Honestly, I don't have a strong recollection of who uttered that into existence.
Mr. Finkel said, one moment, please. Did you ever buy HCN?
No.
Did you ever buy HTO?
No.
Mr. Finkel said, nothing further.
The court said recross?
Mr. Cumraju said, no, thank you, Your Honor.
The court said you may step out.
Witness excused.